Hello, and welcome to The Brief Insight, your go to podcast for breaking down the latest trends, research, and policies shaping our world. Whether you're passionate about sustainability, global economics, or emerging innovations, this is where we simplify complex ideas to keep you informed and inspired. If you enjoy what you hear, don't forget to like this episode, subscribe to our channel, and share it with anyone looking for insights that matter. We're here every Monday and Friday, so hit that notification bell to stay updated. Your support helps us grow and continue bringing you sharp, relevant content that sparks conversation. Thank you for tuning into The Brief Insight. Now let's dive into today's topic.
Welcome back. We get a lot of interesting materials sent our way, but I have to say, this batch is really something.
Yeah, definitely a lot to unpack here.
Seeds. It doesn't get more fundamental than seeds, right? You were talking about plant variety rights, GMOs, patents, trade deals, the whole work. I'm really looking forward to diving into this.
Me too. It should be interesting.
So our mission today is to figure out just what all of this information actually means for seeds. This resource that's so absolutely essential for agriculture and, well, for all of us, really.
Yeah, absolutely. I think a good place to start might be thinking about how different our relationship to seeds is today compared to, well, basically all of human history prior to the last few decades.
Okay, yeah, that makes sense. Take us back in time.
Well, up until around, say, the 1960s, national seed systems mostly worked on this principle of open access. Like if you were a farmer and you needed seeds, the publicly held stores were there for you.
Huh. So it's really a shared resource.
Exactly. It was just kind of how things were done. This idea of seeds as a common good, that's something that's deeply rooted in human societies.
Fascinating. So then what happened? When did things start to change?
Well, a major turning point was 1961. That's when the International Union for the Protection of New Varieties of Plants, or UPOV, was established. And that's really when the push towards privatizing seeds and specific crop varieties started to gain some momentum.
UPOV, yeah, that name comes up a lot in the material you sent. So I'm guessing this seemingly very technical agreement actually ended up having huge real-world consequences.
Yeah, for sure. It really laid the groundwork for seeds. Something that's been a fundamental resource for human survival to become a privately controlled commodity.
And changing the relationship between farmers and the seeds they depend on.
Exactly.
So walk us through this. How did UPOV come about?
Well, the idea was to give plant breeders more control over the new varieties they were developing. But it's important to understand that the concept of privatizing something like seeds, well, it didn't just take hold overnight.
Oh, so there was pushback.
Yeah, there was actually quite a bit of resistance at first. In fact, for the first 7 years after UPOV was created, only a handful of European countries even signed on.
But today it feels like the situation is very different. Almost like this whole push to regulate and standardize and privatize seeds has really accelerated.
It definitely has.
And I get the sense from what you sent that this push is being driven, at least in part, by the desire to expand commercial markets, right?
That's a big part of it, for sure.
Can you talk a little bit about the mechanisms behind all this? Like, how is it happening?
Well, there are a lot of interconnected parts to this. On the one hand, we have the increasing use of what are called plant breeders' rights. It's kind of a specialized form of intellectual property protection just for plant varieties.
Okay, so that's one piece of the puzzle. What else?
Well, then, you have traditional patent laws being applied to seeds and even to specific traits within plants. It's kind of amazing to think about patenting a trait. And alongside these legal tools, you also have these seed certification schemes that set standards for seed quality, variety registries that list officially approved varieties, and then all these marketing laws that govern how seeds can be sold.
It sounds like a whole tangled web.
Yeah, in a way it is. And all these different aspects work together. They create the system where legal control and commercial value get attached to seeds.
So it's not just one thing, it's the whole system.
Right. And it can have unintended consequences too.
Like what?
Well, take seed certification schemes. They aim to ensure quality, which is good, but they can sometimes inadvertently favor large commercial varieties over more diverse local ones. It can be harder for smaller farmers to meet those standards.
That makes sense. So it can create a kind of a built-in advantage.
Exactly. And then with things like variety registries, you have this official list that further solidifies this idea of private control over these varieties.
And all of this is playing out on a global stage, isn't it? Because we're also talking about international trade deals, right? I noticed that a lot of contemporary trade agreements now include UPOV, specifically the 1991 version right in their intellectual property sections.
POV91. Yeah, that's right.
So why is this so important? Why put it in trade deals?
I think if we zoom out and look at the bigger picture of globalization and international commerce, that's where we see why. By including UPOV 91 in trade agreements, it gets real teeth. Countries that sign these deals are essentially mandated to grant these exclusive rights to plant breeders. And we're talking about the whole gamut, production, sale, export, import of these new
So it's
varieties.
not just a suggestion, it's a requirement.
Yeah, pretty much. And when countries sign on to these agreements, often they have to revise their own national laws to make sure they're compliant. It creates a very strong incentive to adopt these privatization measures.
I see. So what does all this mean for farmers in practice, especially smallholder farmers, those who are so vital in many parts of the world? What are the actual on-the-ground consequences of all these agreements and regulations?
Well, that's a really important question, and the consequences can be quite significant. For one, it means that farmers can only legally get these privatized varieties through authorized sellers. They can't just get seeds from their neighbors or their communities anymore like they might have in the past.
That seems like a huge shift from traditional practices.
Yeah, it really is, and it goes even further. In many cases, they are actually prohibited from even exchanging those seeds. Even something as simple as sharing seeds or gilting them within their community can become illegal.
Wow. That fundamentally changes how farming communities have functioned for, well, forever. And it doesn't stop there, does it? I understand that some countries that have adopted UPOV 91 have even gone as far as preventing farmers from saving seeds from their harvests to replant the next season.
That's right. And sometimes, even if they are allowed to save seeds for their own use on their own land, they might have to pay a royalty fee to the breeder. Imagine that. You grew the crop, harvested the seeds, but you have to pay to use them again.
It seems counterintuitive. So what's the rationale behind that?
Well, the argument is that the breeders need to be compensated for their work in developing these varieties. And, to be fair, developing new varieties can be a costly and time-consuming process.
I get that. But still, it seems like it places a significant burden on farmers, especially those operating on smaller scales.
It definitely does. And there's another aspect of this that I think is particularly concerning, especially in the long term. Farmers often can't even use these protected varieties to develop their own new varieties, varieties that might be even better suited to their particular conditions.
Oh, so it restricts their ability to innovate as well.
Exactly.
That's a huge issue. And it makes the importance of what our sources call farmer-managed seed systems even clearer, especially in the global south. Can you tell us a bit more about these systems and why they're so crucial?
Absolutely. Farmer-managed seed systems are basically the traditional way farmers have always handled seeds, going back centuries. This involves saving seeds, exchanging seeds with other farmers in their network, and sometimes even selling seeds within their communities.
So it's very localized and community-based.
Exactly. And it's incredibly important. One of the papers you sent cited research from 10 African countries, and guess what? 90% of the seeds that small farmers in those countries were using came from these farmer-managed systems.
90%? Wow, that's really striking.
Yeah, it really highlights just how central these systems are, especially in those parts of the world.
So what are the specific advantages of these farmer-managed systems compared to relying on, commercially produced seeds?
Well, there are several, and they're all really important. First of all, these systems are absolutely essential for developing and preserving local and indigenous seed varieties. And these varieties are often uniquely adapted to the specific conditions of a region. The soil type, the rainfall patterns, the local pests and diseases.
So it's about resilience and adaptability.
Absolutely. They've basically co-evolved with their environments, which makes them more resilient and potentially better equipped to handle the challenges of climate change.
That makes perfect sense. Using seeds that are specifically adapted to local conditions is going to be more effective in the long run.
Yeah.
Are there other benefits too?
Oh, yeah, for sure. Cost is another huge factor. Obtaining seeds through these farmer-managed systems, it dramatically cuts down on costs for farmers, and it helps prevent them from becoming reliant on those often expensive commercial varieties. And then there's the social aspect. These systems are like vital social networks, right? They're spaces where farmers can get together, share knowledge about different seed varieties, exchange resources and tips, and just generally learn from each other.
So it's about community resilience as well, not just the resilience of the seeds themselves.
Exactly. And then we can't forget about the potential cultural significance that some of these unique local varieties have within their communities. Seeds are more than just seeds. They're part of a cultural heritage.
It's sad then to see countries like the UK,
Hmm.
actively pushing for UPOV 91 compliance in their trade deals.
Right.
I mean, according to what you sent, the UK has encouraged or even outright required it in a whole bunch of trade deals, like a lot of countries, including many in the global south.
Yeah, it's pretty widespread.
And it covers a lot of ground, 68 countries, including 19 in the global south, with something like 30 million small farms. That's a huge number of people potentially impacted by these policies.
It really is. And what's even more striking is that the UK isn't the only one. The EU, the US, Japan, Canada, they're all involved in promoting similar seed protection laws around the world.
That's not a surprise, I guess. It seems like most of the big players are all on the same page here.
Yeah, I think that's fair to say.
And the fact that UPOV 91 is written into these trade agreements gives it a kind of authority that other agreements about seeds don't really have, right?
That's exactly right. If a country signs a trade deal that includes UPOV 91 and then they don't put the necessary legal framework in place, well, they could face sanctions or penalties from the other countries in that agreement.
So there's real power behind it.
Absolutely. And this is where things get tricky because on the other side of the coin, there are agreements like the Convention on Biological Diversity and the Sustainable Development Goals and UNDROP, the UN Declaration on the Rights of Peasants, which we talked about earlier. And those agreements recognize farmers' rights.
They acknowledge that farmers should be able to save, exchange, and even sell seeds. They even emphasize supporting farmer-managed systems.
Yeah, but they don't have the same legal weight, not like these trade deals with UPOV 91.
So it creates this tension, this imbalance,
Yeah.
where farmers' rights are acknowledged on the one hand, but then on the other hand, there's this powerful legal framework that can actually restrict those rights.
Exactly, and it's a tension that's playing out all over the world. But the good news is that there are some really inspiring examples of resistance to these trends.
Oh, yeah. Tell me about them.
Well, the Supreme Court in Honduras, they actually revoked some restrictive seed laws. And they explicitly cited UNDROP in their decision, arguing that these laws infringed upon their sovereignty and their constitution.
Wow, so they used international agreements to protect their own national interests.
Precisely. And then you have India, where their national laws actually already include provisions that recognize farmer-managed seed systems.
So it's baked into their legal framework from the get-go.
Yeah, which is really interesting. And then in Benin, civil society groups campaigned and successfully stopped the government from joining UPOV.
So it shows that it's possible to push back and win.
Absolutely. And these cases, they're really encouraging. It shows that people are aware of these issues and they're actively fighting for their rights.
That's a great note to transition on, actually. Because it seems like it wasn't always like this. Like in the U.S., the way seeds were managed in the past was pretty different from how it is now, right?
Oh, yeah, totally different. Early on in the U.S., seed management was largely a public endeavor. When the USDA was founded, one of its main jobs was actually collecting and freely distributing all sorts of seeds to farmers all over the country.
So the government was actively involved in supporting farmers' access to seeds.
Exactly. And even before the USDA, the U.S. Patent Office was doing something similar. And then with the creation of land-grant universities, there was a huge emphasis on building public germplasm collections. You know, germplasm is just the genetic material of plants, and then also doing research that would benefit, the whole agricultural community.
So it's a very different model focused on the public good. So when did that start to shift?
Well, the rise of the private seed trade played a big role. As these private companies popped up and grew, they eventually decided to challenge what they saw as unfair competition from the government's free seed program. And they lobbied for years to shut it down.
And they succeeded.
Oh, yeah. In 1924, Congress caved and shut down the USDA's free seed program. It was a huge victory for the private seed companies.
Wow. So that was kind of the beginning of the end for this public model.
You could say that. And then the next big development was the introduction of actual intellectual property rights specifically for plants. First, you had the Plant Patent Act of 1930, but that was pretty limited in scope. It only applied to plants that reproduce asexually, like through grafting or cuttings. But then in 1970, we got the Plant Variety Protection Act, or PVPA. And that was a much bigger deal.
So the PVPA, that's when things really started to change.
Yeah, the PVPA gave breeders a sort of patent-like protection for 20 years. It gave them exclusive rights to propagate and sell their new varieties.
So that sounds like a pretty big win for the breeders.
It was, but there was a catch. The PVPA also included some really important exemptions. One exemption was that researchers could still use protected varieties for breeding new plants. And then another one said that farmers could save seeds from protected varieties to plant on their own farms.
So even though it was a step towards privatization, it still preserves some key rights for farmers and researchers.
Yeah, exactly. But then the legal landscape shifted again in the 1980s with the application of utility patents to plants. And that's when things really took a turn.
Yeah, the sources you sent definitely highlight utility patents as a major turning point. So tell me, what's the difference between the PVPA and these utility patents? Why is it such a big deal?
Well, the PVPA offered some protection for breeders, but it still preserved those key farmer and research exemptions we talked about. But with utility patents, those safeguards were essentially removed.
Okay, so can you explain that a little more? What happened?
Well, in 1980, the Supreme Court made a landmark ruling in the case of Diamond v. Chakraborty. And this ruling basically said that you could patent living organisms.
Whoa, so that opened the floodgates.
It really did. And then later rulings like the ex parte hybrid case in 1985 and the JEM Ag Supply versus Pioneer Hybrid case in 2001, they just solidified this idea that you could get these broad utility patents on plant matter. And that was a game changer.
It removed any lingering doubt and just accelerated the privatization of plant genetic resources.
Yeah, that's a good way to put it. And importantly, these utility patents didn't have those research and farmer exemptions that were built into the PVPA.
So that's a big difference. The PVPA, while offering some protection, still had some safeguards in place, but with utility patents, those safeguards were gone.
Exactly.
Okay, so tell me more about the kind of control that these utility patents gave patent holders. It sounds like it was pretty extensive.
It really was. With a single patent, you could control not just the plant itself, but the seeds, tissue cultures, any future generations of that plant, crosses with other varieties, even the methods used to produce it.
So it wasn't just the plant, it was everything about it.
Yeah, pretty much. And this created the possibility of completely blocking research on a patented plant without permission. And it also meant that farmers could be prevented from saving and replanting seeds, something that had been, standard practice in agriculture for literally thousands of years.
That seems like a huge overreach.
A lot of people thought so, yeah. And in addition to these utility patents, you also started seeing these bag tag contracts appearing on seed bags. Have you ever noticed those?
Vaguely. Are those connected to patent enforcement?
Yeah, basically, they're like mini licensing agreements that spell out the patent holder's rights. They're really common with genetically engineered seeds, and they specifically restrict farmers from saving seeds.
So it's like a contract you're agreeing to just by buying the seeds.
Exactly. And the enforcement of these contracts can be really aggressive, especially in the realm of GMOs. Like, companies like Monsanto have been known to hire private investigators and file tons of lawsuits against farmers for supposedly infringing on their patents.
It's wild to think that something as basic as saving seeds could lead to a lawsuit.
Yeah, it really is. And all of this focus on intellectual property has had another big consequence: the consolidation of the seed industry.
Right. Fewer and fewer companies control more and more of the market.
Exactly. The potential to make huge profits from licensing patents, well, it created this big incentive for companies to merge and gobble each other up. And we've seen this massive increase in market concentration, where just a handful of firms now dominate the global seed market.
Like at one point, just Monsanto, DuPont, and Syngenta controlled over half of the entire global seed market.
It's mind-blowing. And this has, of course, led to less choice for farmers. And as the research you sent shows, it's often resulted in much higher seed prices, even for conventional non-GMO varieties.
That's the irony, right? The argument for stronger IP protection is often that it will lead to more innovation and therefore more choices and lower prices for consumers. But it seems like it's often had the opposite effect.
Yeah, that's a common criticism. And there's evidence to support that. The USDA actually documented that as markets for crops like corn, soybeans, and cotton became dominated by just a few companies, private research in those areas actually declined, or at least it didn't grow as much as you might expect.
So it actually stifled innovation.
That's what it looks like. It suggests that when you have a few companies with that much power, they don't have as much incentive to innovate rapidly.
It's interesting. You'd think that with more resources, they'd be able to innovate more, but it seems like that's not always the case.
Yeah, it's a complicated issue for sure.
You'd think that antitrust laws would have something to say about all of this consolidation. But from what you've sent, it seems like the Department of Justice and the USDA didn't really step in.
That's a big part of the problem, honestly. They held these workshops back in 2010 to talk about competition in the seed industry, and they got a lot of feedback about these very issues. But in the end, they didn't really do anything. There were some investigations, but they were closed without any meaningful action.
So it's almost like the government has been complicit in allowing this consolidation to happen.
Yeah, I think that's a fair assessment.
Now let's talk about public universities and the impact of the Bayh-Dole Act of 1980.
Yeah.
This was the law that let universities patent and license inventions from federally funded research. What has that meant for plant breeding?
It's had a huge impact. Bayh-Dole led to a massive increase in patenting and licensing by universities. And while the original idea was to help bring publicly funded research to the market for the public good, there are some growing concerns about how it's affecting access to germplasm and the direction of research in plant breeding.
Right, so the worry is that universities are now more focused on generating income from patents and licenses rather than on doing research that benefits the public good.
Exactly. And this has real consequences.
Yeah.
There have been cases where university licensing agreements have actually prevented independent researchers from doing research on important crops. Like, there's this example of corn insect specialists who had trouble studying genetically engineered crops because of restrictive licenses from biotech companies.
So the control extends even to the research itself. That's pretty worrying.
It is. And then there's this whole other issue of patenting naturally occurring traits in plants, which is just adding another layer of restriction on access to genetic resources.
It sounds like we're getting further and further away from the idea of seeds as a shared resource.
Yeah, I think that's a fair assessment. And the Supreme Court hasn't really helped matters.
Oh, yeah. What about the Supreme Court rulings?
Well, there was the case of Association for Molecular Pathology v. Myriad Genetics. And in that case, the court said that you can't patent isolated human genes because they're products of nature. But in the same ruling, they upheld utility patents on plant varieties.
So human genes are off limits, but plant varieties are fair game.
Basically, yeah. And then in the Bowman v. Monsanto case, the court sided with Monsanto and said that farmers can't reproduce patented seeds. So even if you buy patented seeds, you can't save the seeds from your harvest and plant them again. You have to buy new seeds every year.
So the court has basically reinforced the restrictions on farmers' ability to save seeds.
Exactly. And that's why there's this growing movement to challenge utility patents on plant genetics. The argument is that they're just the wrong tool for this context, that they're actually causing a lot of harm.
So they're stifling innovation, driving up prices, and hurting farmers. What are some potential solutions? What can be done about all this?
Well, there are a few things. First, we need a serious investigation into the concentration in the seed industry. And we need to look at how intellectual property laws and antitrust laws are interacting. Because right now, it seems like the system is rigged in favor of these big companies.
And it's not just about companies, it's about research too, right?
Yeah, those restrictions that are often found in licensing agreements, the ones that limit research and sharing of germplasm, those need to go. And we need to have a transparent process for evaluating the impact of mergers and acquisitions in agriculture before they're allowed to happen.
So basically, we need more scrutiny and oversight.
Exactly. And then there's Bayh-Dole. We need to take a hard look at how it's affecting public plant breeding. We need to figure out if university patents and licenses are actually reducing access to germplasm.
So a reassessment of the whole system is needed.
I think so.
And what about alternatives to the current intellectual property model? The sources you sent talk about things like the Open Source Seed Initiative or OSSI. What's that all about?
Yeah, OSSI is a great example. The idea is to create IP models that ensure that people can use plant material for further breeding and that farmers can save and replant their seeds while still making sure that breeders are fairly compensated for their work.
So it's about finding a better balance.
Exactly. And there are other models out there too. The key is to create systems that prioritize fairness, diversity, and shared benefits. We need to promote equitable exchange of seeds, support genetic diversity, uphold farmers' rights, and make sure that public research actually serves the public good.
It's about shifting the focus away from pure profit and back to what's best for everyone.
Yeah, I think that's a good way to put it.
And this isn't just a U.S. issue, right? This is a global fight.
Oh, absolutely. There are farmers groups and civil society organizations all over the world that are fighting back against the corporate takeover of seed systems. They're speaking out against these restrictions on saving, breeding, sharing, and distributing seeds because they know that these practices are essential for food security, for resilience in the face of climate change, and for protecting biodiversity.
Well, I have to say, this has been a very thought-provoking deep dive. We've gone from the history of seed management to the complexities of international trade agreements and patent law, and we've seen how it's all connected.
Yeah, it's a complex web for sure.
So to sum up, we've seen how seeds have gone from being this freely available public resource to a largely privatized commodity. And this shift has been driven by intellectual property laws and by the consolidation of power in the hands of a few big companies.
And this has huge implications, not just for farmers, but for the diversity of our crops and for the future of our food systems.
And it's highlighted this very real tension between the rights of plant breeders and the rights of farmers. And international agreements and national laws are often at the center of this conflict.
Yeah, and it's an ongoing battle.
But the fact that we see successful resistance movements in places like Honduras and Benin gives me hope. It shows that collective action can make a difference, and that it's crucial to listen to the voices of those who are most affected by these policies.
I agree. Those examples are really inspiring.
So I want to leave our listeners with this. As you're eating your next meal, think about the journey of the seeds that made that food possible. Who controls those seeds? And what does that control mean for our future? What questions has this deep dive raised for you about the balance between innovation, ownership, and the common good?
Those are the questions we all need to be asking, and the answers are going to shape the future of food.
Thanks for joining us today and for sending in all this great material. Keep those questions coming, and we'll keep exploring them together.
It was great to be here.
And we'll see you next time.